welcome to the show, everybody. I'm sitting here in discussion with Kathryn Tucker. Lovely to have you back on the show, Kathryn. How are you doing?
Thanks so much for having me. I am well.
Awesome. And yeah, this is a Psychedelics Weekly episode, so we've got tons to talk about. There's always loads happening every single week in the world of psychedelics. And because so much has been happening with a legal tinge to it in the legal world, we really felt like you'd be a great person to bring on board to explain some of the big picture issues and some of the major things that you're working on right now.
Right. Well, thanks for having me back. I think when we spoke almost a year ago or so, the case that we refer to as Ames 1, Ames versus DEA, was pending, and a lot has happened since then. So I'm here to bring everyone up to speed on all that's happened since then.
Awesome. Yeah, so let's jump into it. Before we go into the issues, just tell folks about yourself. So who you are, what you do, where you're working at the moment.
Sure. So I've spent 35 years in advocacy to protect and expand the rights of dying patients. That has been the focus of my career. I've done it primarily from nonprofit organizations, where I've been director of advocacy for a number of national nonprofits doing that work. So I come into the arena related to psychedelics because of the efficacy of psychedelics in relieving end-of-life distress. And my work has been largely focused on opening access to psilocybin-assisted therapy for dying patients because the clinical trials show such immediate relief. And that is filling a gap in the palliative care toolbox. We have made huge strides in the past 3 decades to do a better job of caring for dying patients in a host of ways. But one of the obvious gaps was a tool to relieve non-physical suffering. And that's what psilocybin-assisted therapy reportedly does, based on the trials coming out of places like UCLA, Johns Hopkins, NYU. And so, my work is focused on that patient population and that particular psychedelic.
Got it. And since we last chatted, you've no longer at a merged law group, but you're now at the National Psychedelic Association. So tell people about the National Psychedelic Association. Yeah, who are you and what's the plan?
Sure. So, as you know, there are a lot of new organizations standing themselves up in the psychedelic arena. I'm also involved with the Psychedelic Bar Association, which is another new nonprofit in this space. The National Psychedelics Association is focusing on making insurance products available to any who come in to serve people with psychedelic assisted therapy or services. So they are very eager in Oregon, for example, to be providing insurance products to people that will be participating under the Oregon Psilocybin Services Act. I came into the NPA in September to add an advocacy component, and I brought with me the work that I'm doing to open access to psychedelic assisted therapy, which includes the Ames cases.
Awesome. Looking forward to seeing the NPA kind of evolving over time, but also I'm hoping that there'll be an ecosystem of all of these new nascent organizations really supporting each other's work. And there's tons to be done, and definitely with insurance, because we're looking at becoming licensed as a training provider in Oregon. And yeah, a lot of the training companies there are struggling on that piece around insurance.
Sure.
And just the difference between state and federal, which we'll come to later.
Yeah.
Okay, so let's jump into your right to try work. And just to get people up to speed, so say the last couple of years, in a nutshell, where are we holding, particularly around the work of Dr. Agarwal
Right.
and his Ames clinic in Washington State, and how it's evolved from there?
Right. So Dr. Sunil Agarwal is a palliative care physician in the Seattle area. He provides care primarily to patients with advanced cancer, and he's knowledgeable and provides ketamine therapy. In his training, he was involved with some of the clinical trials around psilocybin-assisted therapy for dying patients. So he's very aware of the benefit of that therapy for that population. And working with Dr. Agarwal, we initially approached the DEA to find out how the DEA would accommodate state and federal right to try laws. These are laws that are designed to make certain investigational drugs available to patients with life-threatening conditions, recognizing that that population does not have the luxury of time to wait for new drug approval to wend its way to completion. So for patients in that population, anyone with a life-threatening condition, if an investigational drug has cleared a phase 1 clinical trial and remains under investigation, it becomes an eligible investigational drug for right to try purposes, which means that a physician should be able to approach a manufacturer of the drug and obtain the drug for therapeutic use with patients with life-threatening conditions. So Dr. Agarwal wanted to access psilocybin, which is an eligible investigational drug for his dying cancer patients. And on his behalf, we approached the DEA to make inquiry, how would it accommodate state and federal right to try laws? The DEA initially responded by saying no access could be possible. And so we took that as a final answer, and we went into federal court in a case, Ames versus the DEA. We now refer to that as Ames 1. What happened in that litigation is the agency tried to avoid the court reaching the merits by arguing that its decision had not been final. And so the court basically accepted that at face value. And in January of last year, the court dismissed the case without reaching the merits of the right to try argument, because it said the courthouse doors aren't open. You don't have sufficiently final agency action. So immediately we went right back to the agency and we did two things. First, we asked for a final agency action on the right to try request. But a second step we took was to petition the DEA to reschedule psilocybin off of Schedule 1. The DEA responded to both of those requests last summer, and it denied both of them. It happened to respond to the right to try matter first, and so we filed a petition to review that in the Ninth Circuit Court of Appeals in a new piece of federal litigation that we now refer to as Ames 2. But because the agency very soon after denied the rescheduling petition, that also opened an avenue to go into federal court, and we have done so in the case known as Ames 3. Ames 3 is the appeal of the agency denial of our rescheduling petition. That is the active matter moving forward in the courts. We asked the court to put Ames 2 on hold because if we prevail on our rescheduling petition, the barrier to access will evaporate because the barrier was the placement on Schedule 1. So tomorrow, on February 8, the petitioner, Dr. Agarwal, we will file his opening brief in the Ninth Circuit Court of Appeals on the rescheduling appeal. A week later, the friends of the petitioner, friends of the court, amici, will file their briefs in support of petitioner. And you'll see quite a robust array of amicus participation. And in the month of March, then the DOJ, on behalf of DEA, will file the responding brief. And a few weeks later, the petitioners will have a chance to file in response to that. That will complete the briefing. The court will set an oral argument for a hearing sometime in the future, and then we'll have a ruling. So that's kind of the sequence of events.
Thank you. So I think I followed that. I hope everyone listening did too. That's a lot. That's a lot of shenanigans. It's like a soap opera with the DEA as the major protagonist here. But you're not giving up. And it sounds very very powerful just to speak about the rescheduling piece, because
Yeah.
that has such massive implications for so many, different real life situations of people wanting to use psilocybin. Is it just psilocybin that's on this brief, or are we talking about other drug psychedelics too?
So on this rescheduling petition, the reference is only to psilocybin. However, the potential of this case, and this is why it's so significant, is this case has the potential to change how DEA responds to any rescheduling petition. So, as you may know, for more than 50 years, the DEA has denied rescheduling petitions related to cannabis. And there has been a long string of litigation seeking to compel the DEA to reschedule cannabis. And all of those have failed. And they have failed for a variety of reasons. The petition that we have presents the opportunity to finally stop the DEA from a couple of things that have been problematic in these reschedulings. First of all, when the DEA is presented with a rescheduling petition, it is obligated by law to take certain steps. One of the steps it is obligated to take is to seek a medical and scientific evaluation from the agencies with the expertise to provide that. Let's remember, the DEA is a law enforcement agency, and Congress was well aware that that law enforcement agency did not have scientific or medical expertise. So the statutory scheme requires the DEA to go to the HHS, Health and Human Services. HHS has delegated to the FDA, Food Drug Administration, the task of preparing a scientific and medical evaluation on rescheduling petitions. Here, the DEA did not request any scientific or medical information before it denied the petition. That's just a flat failure of duty. And so that's one of the bases that we are asking the court to remand the matter to the agency so that it can follow proper procedure. As you may have seen just last week in Australia, MDMA and psilocybin were rescheduled. And you might have noticed in the press release a reference to the fact that the Australian agency took in a considerable amount of medical and scientific data when it was considering that rescheduling. That's proper. That's necessary. That did not happen here. And so what happened in Australia sort of exemplifies and throws into sharp light that the DEA failed as a matter of process here. In addition to that failure, the DEA applied an erroneous test to the rescheduling petition. So this is another ground of appeal. When you're in court, you can ask the court for various reasons to overturn what an agency has done. So we have a number of different reasons we're asking the court to overturn what the agency did. And the court can do so on any one of a number of grounds.
One question I've got, Kathryn, for us to think about is, what are some of the main arguments to justify rescheduling? So, in a sense, why is psilocybin in Schedule 1?
Yes.
And what's the difference between that and Schedule 2?
Yes.
And how do we convince a judge of that?
Yes.
That it's safe? Like, do we have enough evidence?
Yes.
And I'm playing devil's advocate here.
Right. Well, so, the good news is that if the agency had done its job and gone to HHS and or FDA asking for that medical and scientific evaluation, there is a great abundance. There's a plethora of evidence from studies out of Johns Hopkins, NYU, UCLA, that all show the safety and efficacy of psilocybin in clinical trials. Now, those clinical trials remain underway, but a couple of really important things have happened. As you may know, the FDA has granted psilocybin breakthrough designation twice in recent years. That is the FDA itself recognizing that this drug has an important use and should be available for certain populations, those with life-threatening conditions. So had the DEA sought the evaluation from the FDA would certainly have so informed the DEA. That would have properly led the DEA to open a rulemaking proceeding, at which time all stakeholders, clinicians, and researchers who have firsthand knowledge of the medical and scientific information bearing on psilocybin, people like Roland Griffiths and Matthew Johnson at Johns Hopkins and Tony Bosis at NYU and Charlie Grobe at UCLA, these scientists and researchers could all have come in to give public comment in the rulemaking proceeding. That's what's supposed to happen. That didn't happen here. But if it happened, and as we hope it will happen after the court sends the matter back to the agency, yes, there will be a tremendous amount of scientific data about the impropriety of psilocybin's placement on Schedule 1, and it's the proper placement for it.
Thank you. So a few thoughts. Schedule 1, the main pieces that we know about it is high addictive potential, causes harm, and secondly, that there's no known medical benefit. And we know that that's not true. We've known that for decades, but yes, there's just no way we can avoid it now.
Yes.
The FDA, like you said, has given them breakthrough status.
Yes.
Clinical trials are, moving into phase 3 now with Compass and with Usona. And what we're seeing in Oregon and in Australia, both of those situations, the folks that built that infrastructure, they did a deep dive into the research. So you could see in Oregon, the folks that were, providing the OHA, Oregon Health Authority, with kind of recommendations and a summary of what we know so far, they did a very comprehensive kind of global assessment of all the research that they've got from now and in the past. And, therefore, to say to Oregon lawmakers, there is merit to this. This can work. This is needed. People
Well, let's
will benefit
remember the Oregon measure was adopted by direct democracy, by the voters. It was not in a policy proceeding with legislators. So the convincing that needed to be done in Oregon was the convincing of the voter. And that was successful. But let's remember again, and I think we'll talk about this later, the Oregon Psilocybin Services Act does nothing more than create a state safe harbor. It does not alter federal law. So any psilocybin services in Oregon remains criminal as a matter of federal law with very serious penalties. And so we don't know that a single person will access psilocybin services under the Oregon law and be free of federal criminal exposure. So I think we can circle back to that later. But yeah,
Sure.
The point here is that the DEA needed to take a look at the medical and scientific evidence, and it failed to do that. That's what makes this case what one would consider a relatively easy case for the reviewing court. And what we hope will happen is that the court will send it back to the agency. We hope that the court will retain jurisdiction because this agency is known for delay and for failure to follow up on the direction of the court. So we'd like the court to retain jurisdiction to make sure the agency does the right thing, and it does it in a timely manner because patients' lives are at risk. One of the amici communities that will come in will be the Veteran Mental Health Coalition. Mm-hmm. We know that something on the order of 20 veterans a day die by suicide. And the evidence is that psilocybin is an effective therapeutic for relief of life-threatening PTSD. as well as MDMA, which is another psychedelic that also is an eligible investigational drug under right to try law. So we are glad to see the veterans bring their considerable profile into this case to say there are lives at stake here. And this court needs to send the agency back to do its job.
Has it happened before, Kathryn, that a lot of researchers, organisations, non-profits have got together, shared their research, given testimony about an issue of drug scheduling or of drug policy? Has that happened before in the recent past?
Well, it certainly just happened in Australia. And I invite you to take a look at what the Australian government released when it made that announcement is, they went through a process. Their initial determination was to not reschedule. But because they took public comment and there was an outpouring of comment that spoke to the science and evidence that supports access, the agency then went ahead in light of all that information and made the determination to reschedule. We think that's what would happen here. In our petition that was initially filed last February, so a year ago, we attached the article from the Johns Hopkins researchers, Matthew Johnson and Roland Griffiths, that spoke to the impropriety of psilocybin being on Schedule 1, saying that it was absurd that it was placed there, and that proper placement might be Schedule 4. So in our petition, we pursued rescheduling to Schedule 2, which is the smallest step, but an important step, because let's remember, placement on Schedule 1 makes research difficult. It imposes costs and burdens that make it very difficult for researchers. So one of the benefits of movement to Schedule 2 would be the easing of those burdens, the lessening of those costs that could speed the research and make movement to a different schedule, a less onerous schedule, easier. So we don't know what's going to happen here. And what we hope is remand for the agency to receive data. In that proceeding, stakeholders can come in and argue for the schedule placement that they believe the evidence supports.
Got it. I want to talk about the safe harbor piece you mentioned earlier, but before we get to that, I'm in New Jersey, so my senator's Senator Cory Booker, and I must say I really do like a lot of what he's done over the years. I really do, in many, many ways, personally, professionally, and he's part of a team with the Breakthrough Therapy Act.
Yes.
Can you just talk through what that is and how it fits in with this kind of parallel process that we've spoken of so far?
Yes. Well, of course, when you embark into advocacy, you don't know what front of the battle will be successful. So here, when we began with the Right to Try effort, one of the things we were inviting federal legislators to sit up and take notice is that the DEA refusing to allow right to try access was essentially thwarting and nullifying duly enacted state and federal law. And so the first thing that Senator Booker, with a very bipartisan introduction with Rand Paul, introduced the Right to Try Clarification Act, which was a federal bill that was going to do a very narrow thing, and that was going to clarify that Schedule 1 substances were indeed subject to right to try. That act, that introduction of the Right to Try Clarification Act was soon followed and really eclipsed by Booker and Paul introducing the Breakthrough Therapies Act. That introduced bill does more. And of particular interest to this conversation, it essentially would provide that when a drug is granted breakthrough status, as psilocybin has been, that it would automatically be moved off of Schedule 1 and onto Schedule 2. So that's a really important introduction That introduction has been widely supported. For example, again, circling back to the Veteran Mental Health Coalition, as you may know, and probably you've had many of the veteran advocacy groups on your program, as you know, what they've been doing is having veterans leave the country they served to go outside the United States to where they can get psilocybin or MDMA assisted therapy. And what the veterans have said that's morally reprehensible. And so it's good to see them stepping up and saying that, both in the federal legislative arena with regard to the Breakthrough Therapies Act, and in the federal judicial arena by their amicus participation in AIMS 3. It's important to hear those voices alongside. We'll certainly see clinicians who know this tool should be in their palliative care toolbox. We're going to see a very large amicus brief filed by physicians whose specialty is hospice and palliative medicine. They want to be able to offer this to their suffering, dying patients. So we'll see a clinician amicus brief. The veterans will come in. We'll see mental health advocates. We'll see researchers. We'll see patients' rights advocates. So it's going to be a very wide array of stakeholders that come into the AIMS 3 proceeding.
In a way, because AIMS 3 is so broad with rescheduling, you can bring in all the research and all the kind of scientists and clinicians doing that work now, and there's lots of them.
Yes.
I'm particularly interested in the addiction side of psilocybin work. There's some great stuff coming out. I think NYU.
Yes. And I
think
just
University
was
of Madison
talking,
as well has got some great work with depression.
Yes, and I was just speaking with a researcher out of the University of Washington that is an addiction psychiatrist, and he is eager to get studies up and going at the University of Washington, which is a great research entity, focusing on psychedelic assisted therapy for relief of addiction. And one of the things he shared and lamented about is how expensive those studies are when these substances sit on Schedule 1. So again, one of the ways we can make it easier for this research to go forward is to move it off of Schedule 1.
Yeah, it's funny, just as a tangent, Kathryn, if you're familiar with Rick Strassman and his work with DMT in the 90s, I just finished that book, The Spirit Molecule, and he's talking about, he goes through his one chapter of the book, the design process for the clinical trial, and just how ludicrous it was going between all these federal departments and universities, and in the end he had to go to David Nichols to actually make the DMT for him, and who would then ship it. So it just made it so cumbersome that and it had to be done in an intensive psych unit, which wasn't very congruent with people's experiences. So it is time to reschedule psilocybin, I think, and just look at the research and ask the expert's opinion. And Bill Richards, for one, his work at with patients with oncology and the depression and anxiety that they get, I'm sure he'll be finding something, because he's a legend with a lot of experience with this work.
Yes, well, Bill Richards and his colleagues at the Sunstone Institute, Dr. Manish Agrawal, not to be confused with Sunil Agarwal, but they came in as amici in AIMS 1, and we hope they'll come in as well in AIMS 3, and also bring their expertise forward in a rescheduling proceeding if we can see that proceeding opened.
Got it. Okay, good luck. Yeah, we're all fighting for you here. So this is happening on a federal level. You mentioned about the safe harbor rule, so I definitely want to go into that a wee bit, because something that I've noticed since the midterms, tons of states are having representatives put bills down in both houses sometimes around psychedelic decrim or legalization, or kind of research institutes or kind of task forces. I've lost count. I used to try and test myself to see if I could remember them. There's just so many now. And if anyone wants to go to Psychedelic Alpha, they've got a great tracker, a map of America with what the status is in each state. But, it just seems that since the midterms, things have really shifted. They're picking up the pace on this state level.
Yes.
But I understand there's potentially some concerns that you might have around this kind of piecemeal approach. And is that to do with the safe harbor?
Yeah, I mean, the problem with state legalization, as mentioned earlier, is that it can do no more than offer state safe harbor. It cannot alter federal law. And so in Oregon, for example, which was the first state to legalize access to psilocybin for adult use through the Oregon Psilocybin Services Act, which was passed in 2020, but then had a 2-year ramp up where the Oregon Health Authority engaged in a rulemaking to set up the program for everyone involved to be trained and licensed. So, as you know, under the Oregon statute, all psilocybin must be consumed at a psilocybin service center, which must be licensed by the state. And it must be purchased and consumed at that center in the presence of a licensed facilitator. And that is what is legal under Oregon state law. However, the operation of those psilocybin services centers is still a federal crime. And I think there has been a hope and possibly even an expectation that the federal government is going to look the other way. We have no indication that that is going to happen. And a lot of the hope is based on the experience with cannabis, where after a time, maybe it was 10 years in to the cannabis experience, the federal government did adopt a policy of non-enforcement where states had a regulated program. That was a policy position that the Department of Justice adopted through a memorandum, and that was known as the Cole Memo. That policy position is only as strong as the office holder. So when the Department of Justice had a different leader, that policy was rescinded. So it is not certain that such a policy will issue vis-a-vis any state psilocybin legalization. And it's not certain, even if such policy did issue, how long it would be in effect, which is why I've been working so hard to establish federal safe harbor. The penalties for violating federal Controlled Substances Act law can include 20 years imprisonment and enormous financial fines. So it is no small risk to step outside of federal law. And when we're talking about the treatment of patients with serious medical conditions, normally you want those patients to be treated by a licensed physician. A physician can only do their job when they hold a DEA registration. So violation of federal law by a physician is grounds for revocation of their DEA registration. So it's very problematic to not have a federal permission. The other thing I'll say about the exposure in Oregon under the Psilocybin Services Act, if one is looking for some example of how the federal government might decide to take action against the service centers, one can look at what happened in Philadelphia with the safe injection site. So as you probably know, with the horrific harm of the opioid epidemic, one of the possible measures to combat deaths due to opioid overdose is the idea of opening safe injection sites where trained personnel will be on site, where the drug user can come and do their injection and be supervised so that an antidote can be provided and a life can be saved. There's a tremendous public health benefit to safe injection sites. And following the announcement that such would open in Philadelphia, the U.S. Attorney in Philadelphia first sent a letter and then filed a lawsuit to prevent the opening and was successful. And the argument the federal government made was that the Controlled Substances Act forbids drug-related premises from being maintained. It's the so-called crack house statute amendment to the Controlled Substances Act. So any premises which is operated for the purpose of ingesting a controlled substance that is prohibited by federal law can be the subject of a federal enforcement action. And that happened in Philadelphia, and it shut down the safe injection site. Well, if you just look at that opinion and you take the words safe injection site and you substitute psilocybin services center, you can see the exact same exposure. And, there had been, in the cannabis scenario, the reality that it's very difficult for the federal government to enforce against a multitude of cannabis distributors. There are only going to be a handful of psilocybin services centers in Oregon. So there is not the resource constraint on federal government enforcement. And I just think that assuming the feds are going to look the other way is very cold comfort.
That's very sobering. Yeah. There have been a number of folks that have said that, and it starts a conversation around, is that realistic? Will they really do that? Or come on, they're not that bad. But we, on one level, we don't know what's going to happen, but you've just put down a really good argument. Like, we do know what happened with the safe injection sites.
Yes.
I think I recall, you could help me with it, Kathryn, with the Colorado proposition for the Natural Medicine and Health Act. The way it's been built out, it seems to have language around federal officers not being able to kind of come into Colorado to charge someone, or it might not be that wording, but it says that some kind of language around the federal laws not being applicable, and they will not allow them to be enforced in their jurisdiction. So in my mind, there's people around the border of Colorado making sure no federal officers get in. But how can that be enacted?
Yeah, it can't.
Is that real?
No. The states do not have the ability to override federal law. So Colorado, just like Oregon, is at risk of federal enforcement. So I think, yes, people will be watching Oregon closely. Look, we're now several months into 2023. There have been no service centers opened in Oregon. We don't know what position the federal government is going to take in Oregon. But as happened in Philadelphia, the U.S. attorney waited until the center was about to open before it filed its injunctive lawsuit and prevailed. Now, one of the other things I've heard people say as well, that lawsuit was filed initially when the prior administration was in office. And that's true. However, we're now 2 years into the Biden administration, and we haven't yet seen the federal government back away. Now, it is very possible, and the matter has just been referred to mediation, is my understanding. So it is possible that the federal government, in the safe injection scenario, will negotiate a resolution that allows the service center to open. If it were to do that, it would be because of the public health needs that would be served. In Oregon, it is not as strong a case because, as you know, the Oregon law is not medicinal use, it's adult use. And so any person of age can go to a service center to have the experience of ingesting psilocybin, regardless that they have any medical need. There isn't that strong public health need that one sees in the safe injection scenario. So I don't know, even if we see a mediated permission with regard to safe injection, that would reflect that psilocybin services centers would be allowed to operate. We just don't know.
Yeah, no, granted. And a question I've got is around the clinical trials that are happening with psilocybin now, the two most advanced, Compass Pathways, USONA. So when it gets to the stage of commercialization for their psilocybin, what will be the legal impact? We're hoping, say, that the Breakthrough Therapies Act will be successful in rescheduling psilocybin before that, because that's probably going to take at least 2 years, 3 years for actual commercialization. But what would commercialization of psilocybin do in effect for the states, for people that are already, say, in Oregon or Colorado, that already have their state programs that allow psilocybin for adult use or for medical use?
Yeah, I mean, I think we'll just have to wait and see that unfold. Whether we're successful in the Ames case and rescheduling happens, or whether the Breakthrough Therapies Act leads to rescheduling, either of those successes would have implications for access, probably not the sort of access contemplated with the Oregon Psilocybin Services Act, which is adult use. We're probably going to see some restriction on use, and it may be very considerable restriction. And that may be appropriate. I mean, look, if you take a look at what just happened in Australia, you'll see that what they have allowed is very restricted medicinal use. And that may be appropriate. This jumping to adult use, that may be too big a leap. And we may not see that happen.
Yeah. So we'll wait and see on those. And we're talking about the states. So I'm just going to let folks know there's an article we'll put in the show notes from Marijuana Moment. It's called 4 States File Psychedelic Bills. And those are Hawaii, New York, New Hampshire, and Utah, and many others kind of in that little club there. Hawaii tried last year, I remember. The bill was put down, then withdrawn. And this one is a psilocybin working group. And there's also a bill already in the Senate for MDMA. And in New Hampshire, it's looking like it's legalizing possession for adults aged 21 and over, but they're also trying to remove DMT from the list of controlled substances that are listed under state statute. So I guess that was not included on previous ones. And then New York's really interesting because they have one feature in the bill around the state Department of Agriculture and Markets actually developing a pilot program around how to grow psilocybin-containing mushrooms with the intention of kind of keeping costs low. So just really, interesting things there. And then Utah, legalizing psilocybin for serious mental health conditions is that bill by Senate Minority Leader Luis Escamilla. So tons happening.
A lot of creative thinking. I mean, one of the things that I'll throw out in the creative thinking arena, and it's really not a creative thought that I can claim credit for, but a really interesting idea was floated by a law professor about finding a federal safe harbor where there is a government immunity claim that can be made. So, for example, within the Controlled Substances Act, there's a provision that if the action is taken by a government official, then there is a federal safe harbor. So one of the ways that one might be looking at creatively revising these state legalizations is to have the program be run by the government. Now, could you make an argument that when, for example, the Oregon Health Authority issues licenses to Oregon service centers, that means it's a government-run facility? Maybe. I mean, I think that's an argument worth fully vetting, because it could bring you within federal safe harbor. And for bills that are being introduced now, I think encouraging a look at the government immunity provision and tailoring these state introductions to try to make use of that immunity could be really smart.
Oh, that's a really interesting way. And I'm having a little thought experiment as well, Kathryn, around, I feel like we've been so desperate for so long for change that's why these states are now taking the steps forward, because almost like I think we lost hope that the national level sanity would prevail. But actually it makes it a lot of sense if there could be a federal level reclassification, say, like you're suggesting. And then on top of that, states can tweak things here and there and develop different, pilot projects and different kind of adult use projects on top of that, knowing that, say, it's Schedule 2 or Schedule 3, which really changes a lot of the concerns that folks have if there isn't federal safe harbor.
Yes, absolutely. Absolutely. So it's a super interesting and exciting time. And I know when I was on your show a year or so ago, one of the upshots was that David Bronner, in hearing the show, got excited about doing a direct citizen action at the DEA headquarters, and he organized a demonstration that happened there. And so you never know the far reaches of this show in terms of stimulating how different activists will respond. But I hope one of the reaches will be to the philanthropists in this space. I mean, all the work that I've just described that we've been doing to open access to psychedelic-assisted therapy, that's been funded through philanthropy, and it's really fallen on the shoulders of just a few funders. So for those listening to your program who are in philanthropy and able to direct dollars to important work, we have a fund set up for receiving funds, and at a 501c3 called the NOAC Society, and the fund is called the Right to Try Advocacy Fund. So we really invite your listeners to consider if they can become part of the support for the work.
That's huge. Thank you, Kathryn. Yeah, we'll pop those links in our show notes so listeners can grab that. Great. Speaking about listening, I'm not sure if you can hear my son playing the piano upstairs. I'm in the basement. I just have to apologize
to you,
Kathryn, and to listeners. Yeah,
nice. That adds a lot to the show.
Yeah. There's always something happening when I'm recording.
Right.
And talking about Zoom world and working from home, the last story is maybe not so much in your wheelhouse, but I feel like we need to tell listeners because it's potentially a big deal. We'll have to see how it kind of flops out, but it's to do with the ending of the public health emergency on May 11th. So COVID still is here, folks. Don't pretend it's not here. But the public health emergency, President Biden is saying, will end May 11th. And what that means for telehealth and ketamine providers in particular that work on telehealth is that the Ryan-Haight Act will come back into being. So right now that's being suspended for the public health emergency. So that allowed prescribing of patients to happen and the treatment of patients to happen with ketamine online without seeing them in person. So from May 11th onwards, I guess we're saying that those patients will need to see a prescriber, have a face-to-face, in-person appointment to judge if they're appropriate for ketamine or whatever it might be. So I don't know what contingencies some of these big ketamine telehealth companies that are out there. So folks like there's New Life and Journey Clinical and Wonder Medicine, Mindbloom, just some of the ones that pop in my head. I had chats over the last year and they all said to me, our lawyers are working on that, we've got contingency plans. So I thought it was very diplomatic.
Mm-hmm.
So I'm curious, what does that mean? What's it going to look like? And I have noticed there's one company, New Life, so they did a partnership with Field Trip to utilize their physical clinics. And they also have something called New Network, so that prescribers from around the country can actually onboard to their telehealth platform. So that kind of model I think we'll probably end up seeing more of. And I think it's good in a way to have more in-person contact. I really do. I'm sick of Zoom. I want to see people in real life. And I think for people that maybe haven't used psychedelics before, they've got lots of questions, and it's great to have that physical piece. But at the same time, we want to make sure there's accessibility and affordability. And I know a lot of people in rural areas love telehealth, and it's just changed their lives, particularly if they've got mobility issues or caring issues. They can just kind of schedule it around the rest of their real life stuff. So I'd love it to be a bit of a hybrid model, because I do really think telehealth has been revolutionary for people trying ketamine in the safest place they know, which is home.
Yeah, for sure. For sure. Well, thanks so much, David, for doing this show, and really enjoy your work and appreciate your service of getting this news out there.
Yeah, there's a lot to talk about. Thanks a lot for being here again, Kathryn. And,
my pleasure.
And for all of your wonderful work, and wish you huge success with all the work you're doing, and let us know, and with National Psychedelic Association. So thanks again.
Yes. Hey, thank you so much.
Take care, everyone. Bye.